saucer, right? Good enough. It's too much this side. Yeah. Ganyan, ito ang disturbing na. Dito. Sa bawang dito.
Request everyone to settle down and maintain silence as we will be commencing the round shortly. I also request Once again, can I request everyone to ensure that your mobile phones are either switched off or placed on silent mode. All rise. Good afternoon, everyone. I am Kamat Memorial and I welcome you all to the third edition of the Justice Kamat Memorial National Level Moot Court Competition 2025. I will be your session supervisor and I will be accompanied by Ms. Saisha Mandrekar as your timekeeper. Our judges today are Senior Advocate Surendra Desai, Senior Advocate R.G. Ramani and Dr. Shabir Ali Ji. Respected judges, today T14 represent the petitioners and T1 represent the respondents. T14 Speaker 1 has reserved 23 minutes and Speaker 2 has also reserved 23 minutes for speaking. The team has reserved a total of 4 minutes for a rebuttal. T1 Speaker 1 will be speaking for 24 minutes, Speaker 2 will be speaking for 23 minutes and the team has reserved a total of 3 minutes for a rebuttal. Participants are requested to note that throughout the course of this round, the use of mobile phones is strictly prohibited. Passing of chits may only be done by the researcher, and if there are any documents required to be placed before the respected judges, it may only be done through the court official. In this round, each team has been allotted a total of 50 minutes to make their submissions. Therefore, both participating teams are requested to conclude with their arguments the moment our timekeeper shows the times up plug card. With that, we will begin with the final round of this competition. Therefore, I request our petitioners to make their submissions.
Council seeks permission to approach the dais. The council seeks permission to collectively address the bench as your lordship. Much obliged, your lordship. Your lordship, before the council proceeds with the arguments, the council would like to give a brief summary of facts of this instant case. Your lordship, in this case, there is a state, Madhya Pradesh, which is one of the most advanced states of India. Your lordship, there is the IT sector which has been booming, and because of this, there is a modern urbanization and modernization which can be noted. Religious groups like the current government, DBSS, clearly opposed to this and said and contended that this is something which is eroding the cultural and traditional values of the state. Your lordship, mentioning this, they also started a campaign during their elections in order to restore the culture of the state. Your lordship, once they came into power, there was a law commission which was set up. This law commission had the responsibility to check the live-in relationship trend that has been going on in the state. Your lordship, there were simple statistics which were provided, and which the council would also like to provide, that there were 80% of people between the age of 18 to 25 years of age who preferred live-in relationship over an institution of marriage. Similarly, your lordship, can you hear me now? Your lordship, should the council begin from the part? Like, to continue or to begin from the? There's some. Okay. The council will be allowed, your lordship. So, to continue further, your lordship, the further statistics also provided. With your lordship's permission, the council would like to begin from the starting. Okay. So your lordship, as the council was briefing the honourable bench with the facts of this instant case, your lordship, there is the state of Madhya Pradesh, which is one of the most advanced states of India, as it has one of the most booming IT sectors which is there. Because of this modernization and the urbanization that the state is facing, there is a lot of opposition from religious groups like the current government of BBSS, your lordship. Your lordship, this government contended that even before coming into power, that there were certain modernizations and urbanizations because of which there has been an erosion of the traditional and the cultural values of the state. And during the election campaign, they mentioned to restore the culture and the heritage value of the place. In furtherance of them coming into power, there was a law commission which was set up. Your lordship, this law commission was given the responsibility to check the live-in relationship trend which was going on. Your lordship, after the statistics came into picture, it was held that there were 80% of the couples between the age of 18 to 35 who wanted live-in relationship to be an institution and preferred it more than an institution of marriage. Similarly, 60% of the population did not want to have children but only wanted to focus on their career. It was also noted that there has been an increase of 20% in the cases of domestic violence in the cases of live-in relationship rather than in marriage. Your lordship, with all these things keeping into consideration, the state of Madhya Pradesh passed the Act of Madhya Pradesh Live-in Relationship Regulation and Registration Act of 2024. Your lordship, the problem with this act was that it violated the personal autonomy of the individuals and also other fundamental rights like the equality which was compromised, and it did not really cater to the objective for which it was sought. Your lordship, with that being said, the council here appears on behalf of the Citizens for Democratic Rights in the form of a PIA filed under Article 32 of the Indian Constitution. With the lordship's permission, the council would like to now proceed with the arguments. In much obliged, Your Lordship. Your Lordship, before the council begins with the argument, council would like to submit the compendiums to the Honorable Bench. Your Lordship, on council number 1, I'll be dealing with issue number 1 and issue number 4. And my co-counsel would be further substantiating on issue number 2 and issue number 3. With Your Lordship's permission, the council would like to proceed with issue number 1. Your Lordship, the council on behalf of the citizens of democratic rights respectfully submits before this honorable court that the extraterritorial application of this act is in violation of certain constitutional and fundamental rights which have been enshrined in the constitution. Your Lordship, talking about the constitutional right, Article 245 of the Indian Constitution is being violated, and the fundamental rights, the golden triangle, which is Article 14, Article 19, 1B and E in the instant case, and Article 21 is being violated. Your Lordship, further, this act impermissibly.
You want to know if this is a public interest litigation?
Indeed, Your Lordship.
How is the public interest?
Your Lordship, since the current trend mentions that there are 80% of the people who prefer a living relationship rather than an institution of marriage, it clearly mentions how there is a new norm which is coming into the society which prefers something of an institution of living apart from this. And Your Lordship, the council would also like to submit that in this year itself, 2025, Uttarakhand has passed a similar act. There have been judgments for Rajasthan High Court and Allahabad High Court mentioning as to this act needs to be passed in their states as well. Your Lordship, with this being done, and if the CBR who represent the democratic rights of the individuals feel that this is something which is unconstitutional, we approach the highest authority in the judiciary to get it, for in the public interest, to get it held unconstitutional, so that.
How is it unconstitutional? How is it unconstitutional?
Your Lordship, the council will be substantiating on the same by argument.
But before that, why did you not approach your High Court?
Your Lordship, as the council retaliated that the issue was not only with respect to Andhra Pradesh anymore. There were other high courts, there were other state governments which also started to get similar acts into picture, which clearly violated Article 14, 19 and 21, which the council will be substantiating by arguing. And because of this, it became a matter of such a public interest that instead of going for Article 226, the council seek to sort it better to go for Article 32 under the highest court of judiciary. And it also would save certain amount of time if it is gone to the Supreme Court instead of the High Court, because if other courts are also sending with such the petitions are filed in other High Courts as well, there could be a conflict which would arise, and at the end of the day, the matter will go to the Supreme Court. So the Council for the Democratic Rights felt that that this problem, which is of such a gravity, needs to be addressed directly to the Supreme Court in this instance.
Law is about relations.
Indeed, Your Lordship.
And there is what is the percentage of relations in India?
Your Lordship.
What is the percentage of relations
In India.
Your Lordship, the Council is not aware of the data of India per se, but there has been an emerging trend which is going on, and with concern to Andhra Pradesh, there is an emergence of 80%, Your Lordship. Of how?
80%.
Indeed, Your Lordship.
So this is not in the public interest to see that this is related.
Your Lordship, the problem, the Council would respectfully submit that the problem is not with the regulation. The problem is with the mandatory regulation which the Act has posed, and it has also made them face unwarranted criminal charges if it is not registered within a period of 30 days. Doing this, they have clearly violated all these fundamental rights like the private autonomy which has been compromised, equality has been compromised as to why certain classifications have been made, and as to why if a person has already moved out of that state, be subjected to a state legislature's law when they are not even being governed in that particular state, Your Lordship. And because of this mandatory registration, it becomes a problem of arbitrariness which the Council will be tackling.
How do the fundamental rights are violated? The relationship between regular
Indeed, Your Lordship, the Council will be substantiating on the same. Your Lordship, in the case of Justice K.S. Kutteswamy versus Union of India, it reaffirmed that the right to privacy is a fundamental right, particularly in the matters of personal relationships. Your Lordship, the present law unduly interferes with the autonomy of the individuals to choose the nature of relationship that they would want to have. And secondly, if they have already moved out of that state, why to get governed by the laws of such states legislature? This purely intervenes with how they would want to live their life in a particular manner, Your Lordship. This is how Article 21 is getting violated. Article 14 submissions is comparable to the submissions for Article 245, Your Lordship, which would mention that how the extraterritorial application of this Act is a problem, and the classification that they have made for ordinary residents who have moved out is the problem which Article 14 will be dealing with, Your Lordship. So, with Your Lordship's permission, the Council would like to submit that document. Indeed, Your Lordship, Article 245 of the Constitution, it restricts the state's legislative competence to the matters related to only its state's territory. Your Lordship, further, the Council would also like to cite the case of State of Bombay versus R&D Kamat Memorial, where it was held that the state law must not have extraterritorial operation beyond what is necessary for its enforcement. Similarly, in the case of A.H. Walia versus Income Tax Commissioner Bombay, Your Lordship, the court held that the state laws must be confined to their territorial nexus. Your Lordship, in this particular case, with an attempt to control the relationships and to have legal obligations being imposed to these people, there is a clear violation of these fundamental rights. Further, the Council would also like to submit that this Act's requirement for the mandatory registration of the persons who are the ordinary residents in Madhya Pradesh must comply with the registration is extremely indeed, Your Lordship. Your Lordship. Indeed, Your Lordship, this is flagged. Indeed, Your Lordship, the facts are clearly different, but when the ratio is met. Indeed, Your Lordship. Your Lordship, there is no particular judgment which directly caters to this point because it's one of the rare cases which has come before the Supreme Court of India because this Regulation Act is something which is very new which has happened. But indirectly there have been cases which only specify about the extraterritorial operation, and this case has been cited to ensure that there is extraterritorial application until and unless there is a direct nexus which can be drawn, Your Lordship. And for this the Council has also flagged another case of State of Bihar versus Charasi Dasi, which is flag number 2 on the compendium. Your Lordship, the Council does not disagree that there is no application of extraterritorial boundary which can be done. It can be done, but only and if there is a direct nexus which can be drawn between the objective that the state seeks to achieve and between the reason as to why they are including ordinary residents who have already.
Territorial application for extraterritorial people. People who are coming from outside. If they are in a particular territory, the law applies. The law doesn't go outside the state.
Indeed, Your Lordship. Your Lordship, for this, the Council would like to redirect Your Lordship's attention to Section 2, Clause J of the Memorial Proposition, where they have defined an ordinary resident as somebody who has the address in their Aadhaar and the voter ID card as the one which is there for in the state of Madhya Pradesh. Your Lordship, as you correctly mentioned, if a person who has already been living in the state for a good 10 years but has an Aadhaar or a voter identity card of somewhere else, this person would not come under the purview of this state according to their own definition. And similarly, if there is a person who possesses a voter ID card or an Aadhaar card of the address of the Madhya Pradesh but resides outside, they have chosen them for themselves. Article 19(1)(d) and Article 19(1)(e) clearly allows them to go and settle and move around the country wherever they want to. By doing this, there is a clear violation, indirect subjection of them to the state legislative's law, and that is what the Council is contending is to be arbitrary and against the fundamental rights, Your Lordship.
No, but if somebody shifts his residence from A to B
Indeed, Your Lordship.
permanently, then don't you think that he could get his address on the PAN and voter ID and Aadhaar changed?
Your Lordship, again, the Aadhaar address and everything is something that the people need to do it. And this is done with by mere submissions of rental agreements or electricity agreements with some simple portals like M-Aadhaar. But it does not make it mandatory for them to get it done within the stipulated amount of time or anything. Your Lordship, the clear case that the Council is trying to point here is that a person who has started living in Madhya Pradesh and who possesses the address of some other state, even if they have not gotten the address changed for Madhya Pradesh and has the address of some other state, they are not being bound by the act of Madhya Pradesh itself. But a person who possesses the voter ID card and Aadhaar card of Madhya Pradesh but resides somewhere outside, they will have to comply with the subjection that the state legislature is posing. And your lordship, this actually becomes a problem as to in the cases of maintenance. Your lordship, if there is a woman who needs to be provided maintenance under section 12 of the Madhya Pradesh Act, if the woman is an ordinary resident of this place but she lives somewhere outside and she is married to a man who is not the ordinary resident of this state, this subjection would also apply to that man. This clearly means that this man who is not even the ordinary resident of this particular state will have to comply with the subjection.
As far as applicability of this outside Madhya Pradesh is concerned, it could be read down, no? Provision could be read down to say that as far as those who live outside Madhya Pradesh will not be bound by this.
Your lordship,
That is not, why should you declare the whole provision of law as a constitution?
your lordship, the council here is not trying to prove that the entire act in itself is unconstitutional, but there are certain important provisions of this act which need to be unconstitutional. And as your lordship correctly mentioned, that about the residence of the person, about the residence of the
If
person.
we read down those provisions, you are happy? Read down those provisions.
Indeed, your lordship. Your lordship, the council does not have a problem with the regulation. The council has a problem with the mandatory regulation which comes with unwarranted criminal charges that these people have to face because of the non-registration done within 30 days of compliance. That is the problem, and that is why the fundamental rights are getting violated. Had it been mere regulation, the Council for Serious Act has been brought into picture is clearly mentioned in the memo as to how the current government was wanting to restore the cultural and the traditional values, and live-in relationship is something which is not seen as a general norm in our society. By collecting the statistics and data, they did not want to promote or regulate, but rather to discourage live-in relationships, knowing that in practical world, if they are asked to get it registered, there would be some sort of hindrance to do it, knowing that the parents would get to know, knowing that the society would get to know, and this will clearly invade with the privacy which has been put down under the justice case which is on the judgment your lordship.
How does it reach upon your privacy?
Indeed, your lordship. Your lordship, the
You are
privacy.
openly living in a relationship. So that's the question. Nobody is asking you not to do that. Nobody wants you to be regulated. That's
Your
all.
lordship, for this the council would like to mention that even people who are of the age of 18 to 21, they are asked to get their registration done, and there will be a notification which should be sent to their parents. Your lordship, this is something where they are doing the moral policing instead of safeguarding the interests of the state. Your lordship, why to involve the parents of people who are 18 to 21? Only because when they are adults, they also have the same constitutional rights as their parents do. And if they want to keep it private, if they do not want to keep it open in society or in public, this is something which depends upon them, your lordship. And this is
Maybe
what,
by way of information to the parents.
your lordship,
When they're okay on the line.
your lordship, that would be a moral argument and not a legal one, because Article 21 will still get violated in this case. Had it been a minor, the council would not have had a problem. But with an adult who has already been declared an adult under the Indian Majority Act, this does present as a problem.
No, on information being given, if parents could intervene under the law, that perhaps you are right. But this only giving information to the parents, don't you think that foreign parents without being informed about what is being
Your
done?
lordship, the problem here is that live-in relationship is not something which is considered to be gendered, as the council has already retaliated. Your lordship, this would lead to an increase in cases like honor killing. This would lead to an increase in cases like where the parents would force marriages. There would be termination which would be forced to get it done on the live-in relationships, which clearly violates their fundamental rights. The increase in child.
But it should
Indeed, your lordship.
not fundamental rights. Are they absolute rights?
No, your lordship.
Let's take into the sections.
But indeed, your lordship. But this would not. Indeed, your lordship. The council agrees.
Here they become registration and regulation. The law is dealing with registration and regulation, nothing else.
Your lordship, the
You
problem.
register, for example, marriage, many states are mandating register. Register.
Indeed, your lordship. Your lordship, the council would like to mention that the council agrees that there are certain reasonable restrictions which the state needs to which needs to be provided to safeguard the interests of the citizens. Your Lordship, but in this case, when you're already imposing them with unwarranted criminal charges for not doing a mere registration, that is not a simple regulation that's followed. And this is not something, there are a lot of acts which get it registered, but there are not a lot of acts which ask you to get it registered within a stipulated amount of time, or you will be faced with unwarranted consequences. That is the problem, and that is why it is against Article 14, 19 and 21, Your Lordship.
Once registered over, no issues. If you don't register, only the consequences. If you don't register, consequences.
Indeed, Your Lordship.
No issue.
But the consequences are not proportional, Your Lordship. There was a test which was laid out in the case of K. Putteswamy.
Why do you say Article 21 is violated?
Because, Your Lordship, in the case Putteswamy judgment, it had clearly mentioned that the right to privacy extends to personal relationships as well. And when we talk about personal relationships, it would include the live-in relationship that the two people have chosen for this.
It's not to fortify your personal relationship. It's not to regularize or regulate your personal relationship.
Your
That
Lordship,
nobody comes and says your relationship.
Your Lordship, the council.
See, this is towards protecting your relationship, regularizing it, and recognizing it. After you follow it, it's the procedure. What is wrong in that?
Your Lordship, the procedure, Your Lordship, the council already mentioned that the problem is not with the regulation of the act. It is in the mandatory regulation which comes with certain unwarranted criminal charges which are extremely arbitrary and something which should not have been imposed. Your Lordship, there are a lot of acts of the similar nature and of personal nature, but it does not include these criminal charges. The council would be more than happy if this particular aspect of it, the extraterritorial aspect of it, is let down, Your Lordship. And that is all that the council is here to ask for. The council does not have a problem with the regulation per se. Your Lordship, the
Time's
council,
over.
Your Lordship, the council would just seek 2 minutes of the court's time to just,
Okay.
the council still has time to complete the issue, Your Lordship. Your Lordship, issue number 4 deals with whether the section 12 of the Vidya Pradesh Act is in violation of part 3 of the Constitution. Your Lordship, this particular section deals with the maintenance that needs to be provided or granted to the women. Your Lordship, in this particular case, it is not taken into consideration the man's financial security or stability while the maintenance aspects to be granted. It is not taken into consideration whether the woman is actually in need of such a financial help or stability. This does not mirror in any way or in any manner Section 125 of CRPC, which is now 144 of PNSS, and it does not mirror at the same time Section 24 and 25 of HM. Your Lordship, these two sections, these two parallel provisions provided clearly that Section 24 and 25 of HM provided that either spouse would be considered and their financial stability would be considered, which is not the case in Section 12. Further, Section 125 of CRPC or 144 of DNSS clearly mentioned that when the maintenance has to be granted to a woman, her financial stability and economic stability needs to be adhered to at every point of time, Your Lordship. This is something which Section 12 creates an arbitrary mandate or an obligation on the man of the living relationship to provide, and this is not something which they should have been subjected to. Your Lordship, the Council would also like to mention that legal age for a man to marry in the country of India is 21, but for the live-in relationship, the age is to be 18. But the obligations and the responsibilities that they have been faced with are the same, which clearly makes the sense that the state wants to clearly do away with the difference between the two institutions of live-in relationships and the institution of marriage at hand, Your Lordship. This clearly means that they do not want them to enter into a state of live-in relationship because it would be burdening on them and will not give them a right to exit from that relationship. The Council will seek an extension of 1 minute to summarize the arguments for this one. With Your Lordship's permission.
This is going to be difficult because your friend will get this one.
Your Lordship, my co-counsel would very well handle that situation.
If you allow him to speak for more time, you have nothing less next time. What is the law?
Your Lordship, 1 minute extension is all the Council.
Unless between you will decide.
It's okay. He's all right.
So 1 minute is going to 60 seconds.
1 minute. I assure the court that I will do. Your Lordship, unlike married women who must establish their economic dependence and their financial need, this is not done for the women who are in the live-in relationship because they get it automatically. And this is where the problem comes into picture and does not mirror any of the provisions which are parallel in nature. Further, Your Lordship, the Council would like to redirect your honorable bench attention to the case of Shaya Nawala versus Union of India. In this case, there was the triple talaq which was struck down, but the court also retaliated on the point that the laws must not create any unreasonable classification favoring one gender over the other. But in this case, there has been no responsibility or no blanket which has been given to the men in the living relationship, but only for the female in the living relationship, and it only has. Your Lordship, the court must like.
Still, according to there is more time left for you.
Yes, indeed.
When we say your time is over,
Indeed, Your Lordship. It was an honor argument. Sound pretty good.
let's say something to your
Indeed, indeed. Thank you.
Council's permission to oppose the dais. Make a motion. The council's permission to address the bench collectively as well questions. Lordship, the council number 2 will be dealing with issue number 2 and 3 in a combined manner by way of 5 simple links, dividing the arguments into 5 links. The first 3 links shall be about the violation of the fundamental rights, which is the golden triangle, Article 19, Article 21, and Article 40, which has been established in the case of Maneka Gandhi versus Union of India. Further, the council will be substantiating arguments on the proposed principle of proportionality and the line of distinction between a marriage and a living relationship. If your lordships permit, the council shall start with the arguments. Your lordship, much obliged. Your lordship, the act effectively grants quasi-judicial powers to the registrar, whereas the registrar is an administrative body. Your lordship, this violates the principle of separation of powers and the principle of natural justice. Your lordship, unlike judicial bodies, the registrar is not required to undergo and follow the judicial standard of evidence, the judicial standard of reasoning, which leads to the violation of procedural fairness, Your lordship. Your lordship, the council would like to humbly submit that the Act grants the registrar unchecked, unfettered and arbitrary powers, Your lordship. Such powers to determine the validity of a living relationship without any clear guidelines that have been laid down in the Act per se, Your lordship. Your lordship, the council is not able to clear the breach.
Uttarakhand High Court judgment.
Uttarakhand High Court judgment. Your lordship, we are aware of the same motion. Your lordship, the council would like to submit that the council would request the court to bring your attention to the section 6, page 8 of the Moot Court proposition, Your lordship. Page number 8 and section 6, Your lordship.
Procedure.
Procedure for registration of the registry. Your lordship, clause 2 of section 6, Your lordship, it says that the registrar shall examine the contents of the statement of living relationship so submitted, and the keywords here are, Your lordship, he shall satisfy himself or herself by conducting a summary inquiry. Your lordship, the question here is that who will check that the satisfaction of the registrar is arbitrary or not, Your lordship? How will the citizen know that the registrar is acting in his true sense and he is not acting arbitrarily, Your lordship? Your lordship,
But
clause
under this subsection 2,
Your lordship.
registrar is required to only see that it does not violate section 9, section 5.
Your lordship.
So, summary inquiry would be sufficient.
Your lordship, further the council would like to show
Summary
that
inquiry is not very large. It's very narrow.
Your lordship, the council would like to point out another clause, which is a problematic clause here, lordship. While conducting a summary inquiry, Your lordship, under clause
Subsection 3.
subsection 3, Your lordship. While conducting a summary inquiry to understand the same thing, for the same reason the inquiry be conducted to understand whether it falls under section 5 or not, Your lordship. But under clause 3, Your lordship, the registrar has the arbitrary power to summon the living relationship partners or any person who has been associated with them and summon the same to the court and summon the same to prove the veracity of the statement, Your lordship. Your lordship, if we give the registrar the power to summon any person, it is such powers which the court of criminal procedure has, Your lordship. Is it right to give such powers to the registrar, which is an administrative body, Your lordship? Such powers can be misused and it can lead to arbitrary decision making, Your lordship, which hence violate Article 14 of the Constitution, Your lordship. Your lordship, the council would like to submit the case of Srilekha Vidyarthi with the state of UP. Your lordship, this case is in the compendium, flag number 10, Your lordship. Your lordship, in this case, the court held that Even in the absence of specific guidelines, the exercise of discretion by an administrative body shall be based on reasonable and non-discriminatory standards. Your Lordship, the Act per se is not unconstitutional, but Your Lordship, the exercise of discretion and the powers, Your Lordship, there are no clear guidelines, Your Lordship. There is no power, there is no system of check and balance, Your Lordship. The entire Act, it nowhere mentions about an appellate mechanism that the party should have in case of an inquiry which goes against them. They should have
Section 15 of this Act
Indeed, Your Lordship.
provides for making of rules.
Indeed, Your Lordship. Provides the making of rules, Your
Do
Lordship.
you think that rules can be made to elaborate what is provided in section
The
6?
Council agrees, Your Lordship. The Council agrees, Your Lordship. But Your Lordship, the same rules should have been enacted in the Act itself per se, Your Lordship. And secondly, Your Lordship, there is no mention of such rules being enacted here, Your Lordship. And the Act is given a deadline of 1 month, Your Lordship. Just in case the government doesn't frame any guideline in the duration of 1 month, Your Lordship, all the summary inquiries conducted during that 1 month, Your Lordship, they will face the consequences, Your Lordship. They will not be able to have an appellate mechanism, Your Lordship, which will hence lead to the violation of all the other part of as well, Your Lordship.
That is not your ground. You don't say that because rules are framed, it should not be implemented.
Indeed,
You
Your
don't
Lordship.
say that
Upon Your Lordship.
that is not your ground.
Indeed, Your Lordship. Your Lordship, the main ground being here is that the power.
India Pradesh in India,
Indeed, Your Lordship.
there is it.
It is a hypothetical state in India, Your Lordship.
It is hypothetical.
Why should it make it happen? There are laws.
It
There
is.
is a law which is banned.
It is in pari material with any state of the state of India, Your Lordship, in which such act to be enacted. For the present case, we can say Uttarakhand it can be a very similar state in India.
I think
But
it is the
There is
state
a law
that
governing
first
in Goa.
indeed, Your Lordship. Indeed, Your Lordship. Goa also has the Portuguese civil code, Your Lordship. In the council.
It's equal to regulates its relationship.
No, Your Lordship, it doesn't. But the Uttarakhand civil code does, Your Lordship. Only that civil code does. Indeed, Your Lordship. Your Lordship, in the case of E.P. Royal versus the state of Tamil Nadu, on page number 17 of the memorandum, Your Lordship, it states that arbitrariness is attributed to equality. Your Lordship, any law that enables unchecked discretion shall be struck down. Similarly, in this case, there is an unchecked discretion on the hand of the registrar, Your Lordship. Lordship, any questions?
This also is regulated by the law. This also is regulated by the law.
Indeed, Your Lordship, the registrar is also regulated by the Indian Registrar Act, Your Lordship.
So there are no uncontrolled powers.
But in the present Act, Your Lordship, the power to summon and the power to issue the summary inquiry, that
That
is
is appointed by the government.
indeed, Your Lordship. Your
Also
Lordship,
knows who should be appointed as legislative judicial matter.
Indeed, Your Lordship, Council agree with that. But even after the appointment, Your Lordship, the kind of powers that have been granted to the registrar, they could have been made in such a way that the right of the individual is not violated, Your Lordship. Power shall be granted, Your Lordship. And the due process
So
of
is
law.
the right of individual is violated. Which right of individual is violated?
Your Lordship, currently the Council is talking about what?
Individual relationship is something not properly confined to any law.
Indeed, Your Lordship. The Council would like to.
Regulating, nothing is being violated.
Indeed, Your Lordship.
The wrong is being regulated as.
Indeed, Your Lordship. Indeed, Your Lordship.
So there is violation.
Your Lordship, the Council would like to highlight two fundamental rights that have been violated by this particular law, Your Lordship, which the living relationships do recognize the courts, the Honorable Court has recognized for the living relationships two rights, Your Lordship. The right to choose a living partner under Article 19(1)(c), the right to form association and union, and Your Lordship, the right to have personal liberty, personal autonomy, and the right to privacy under Article 21, Your Lordship. So, Your Lordship, permit the Council to proceed with arguments for the
And
same.
is subject to restrictions, restrictions or not.
Indeed, Your Lordship, it is subject to reasonable restrictions, Your Lordship. But in the present,
Are there not reasonable restrictions? Are these not?
indeed, Your Lordship, the restriction in the present Act, they are not reasonable restrictions, Your Lordship.
Section 5 only gives degrees, prohibited degrees, within which there cannot be limitation. That's all.
Indeed, Your Lordship, the Council agrees with the same, Your Lordship. But, Your Lordship,
Otherwise, there is no prohibition. You are free to have living relations.
Your Lordship, even after checking the Section 5, Your Lordship, there are still some grounds on which the registrar can still deny the decision of a living relationship. The Council would like to highlight the clause 2 of Section 9, Your Lordship, on page 10. Clause 2 of Section 9, Your Lordship. Your Lordship, even if the registrar is satisfied with the requirements of the Section 5, Your Lordship,
No, it was again it was section 5 only.
Your Lordship, it is the keywords that the Council would like to reserve on Your Lordship are suspicious, Your Lordships. Your Lordships, what is the meaning of the suspicion of the registrar, Your Lordship? It would be a very personal opinion of the registrar. Indeed, Your Lordship. Firstly, Your Lordship, the capability of such a provision being
You
used.
cannot give a false information. You cannot make
Indeed,
a
Your
false
Lordship.
statement. That is what is a registered
Indeed, Your
legal
Lordship.
message.
But Your Lordship, the council would like to argue upon the same that why does the person living in a living relationship should be made to go through an inquiry? Why should a person be made to go give a statement of living relationship? People are marrying in India since a long years. There are laws for marriages. There's the Hindu Marriage Act, Special Marriage Act. Do those laws provide any provision for a summary inquiry? Do laws provide any statement to be given compulsorily? No, Your Lordship. It is only the living relationship which is being given restrictions which are much more than marriage, Your Lordship.
Is there any law in India which provides for living relationship?
For living relationship? Your Lordship, Your Lordship, the Honorable Supreme Court has recognized living relationship to be a part of multiple provisions. For example, the Honorable Court has recognized it to be claim maintenance under Section 125 of CRPC, Your Lordship. So the recognition for living relationship by the Union and by the Honorable Court is already there, Your Lordship.
This endorses, okay, there is no law on the subject.
Indeed, Your Lordship, there is no such word.
You know what I'm saying?
Indeed, Your Lordship.
So you are doing something which is not permitted by law.
Indeed, Your Lordship.
Yet you want to do something which is still available to
Indeed,
you.
Your Lordship.
Do whatever you want. That means there is nothing you can control it.
The council agrees with the assertion that lordships are trying to put forward, but the council would also like to assert that when the state is trying to make an act which is to protect the individual in living relationship, the act should only aim to protect. It should not aim to prohibit them from getting into living relationship. It shall place reasonable restrictions for showing lordship. But Your Lordship, provisions such as summoning, provisions such as on mere suspicion of the registrar, the police information, the police department will be informed. If you look at clause 2 of the section 9 Your Lordship, it says that maybe on an incorrect information or suspicion, he or she shall inform the officer in charge of the local police station for appropriate action. Your Lordship, the council would like to ask, what is the appropriate action that the police will take, Your Lordship? The police might criminally prosecute the young couple who is in the living relationship, Your Lordship. Especially if the Your Lordship refer to section 11 on the same page, Your Lordship. It lays down offences and punishment for non-registration of a living relationship, Your Lordship. Your Lordship, merely for a non-registration of the living relationship, which is not a criminal offence in India as of now, Your Lordship. For such a trivial matter, Your Lordship, the Act has given up to 1 year of imprisonment, up to 25,000 rupees of fine, Your Lordship. Your Lordship, such fines and such criminal penalization of young couples is not allowed, Your Lordship. It should not be allowed, Your Lordship. For the same, Your Lordship, there are multiple cases which hold that the state shall endeavour to protect living relationships. The council would like to draw the court's attention to page 21 of the memorial. The memorial arguments that the council has submitted, page 21 of the Your Lordship, in the last paragraph, the case of S. Khushbu versus Kanema has been cited, Your Lordship. Page number 21 of the memorial. Your Lordship, in the case of S. Khushbu versus Kanema, the Supreme Court, the Honorable Court, has recognized that living relationships are constitutionally protected and must not be subjected to unnecessary state regulation. The keywords here are Your Lordship. Your Lordship, the case S. Khushbu versus Kanema, page 21 of the memorial. The submission of arguments. The council shall proceed the application. Page 21 of the memorial.
Sorry, you want to have restrictions on it. You want to do whatever you want.
If the Lordship could repeat the question, the council is not, it's not audible, Your Lordship.
It appears you want to be so free without any restrictions on it. There cannot be any restrictions.
Your Lordship, the council is not against restrictions, Your Lordship. The Citizen for Democratic Rights organization, we only stand for democracy, Your Lordship. The democracy currently is that 30% of the citizens of Andhra Pradesh are in living relationship, Your Lordship. And as you mentioned, the proposition as well, Your Lordship, clarify of the proposition. 30% of the people are in living relationship, Your Lordship. Such quality of population, they shall be considered and they shall be protected, Your Lordship. So when an act is being granted, the reasoning of restrictions might be imposed on lordship, but the personal autonomy of the people under Article 21 shall not be taken away. For example, the Council would like to state a very provision in this Act itself, Section 9, Clause 1, page 9 of the Moot provision, the legislation. The legislation itself says that if either of the partners are under the age of 21 years of age or lordship, the registrar shall inform the parents or the guardians of such partner or lordship. The lordship, why should the parents be involved in the personal matters of the children getting into living relationships and getting into dating or lordships? The lordship, there are multiple cases in places where there is a backward thinking and where the parents might lead to honor killing of their the council agreed to the same way, lordship, but indeed, your lordship, but your lordship, the law has to also change, as the honorable report itself has checked it time and again, that the law has to keep moving on and keep changing with the change in the societal norm and societal thinking, your lordship. And the statistic that we have, your lordship, 80% of the younger generation is vouching for living relationships rather than marriage, your lordship. Hence, we have to consider the same.
It's about the transfer of more from ideas, 80%. What about India? What is the population of living relation?
Your lordship, the
We
data
are in India, we don't join the counseling from idea. What is living population in India?
Your lordship, the council does not have the report, but the Law Commission of India, 242nd report,
Yeah.
it says that at least 30% of the people,
30%.
at least, it is not indeed, your lordship, but see, your lordship, the state shall still endeavor to protect the minority as well, your lordship. If the minority is being thrown away in the name of the development, your lordship, then it's a violation of the minority's fundamental right, your lordship.
Restrictions on your fundamental rights.
Indeed, your lordship.
What are the restrictions? Which restriction they can impose in this situation?
Your lordship, restriction, there can be multiple restrictions that can be imposed, your lordship.
Can you mention which restriction we can impose in this situation?
Your lordship, the first restriction can be regarding age, your lordship. Rather than making a distinction,
I'm not about a restriction under this case. Restriction by the state regarding your fundamental rights.
indeed, your lordship, the state can make restrictions for this, the council would like to cite the 4-prong test in Maneka Gandhi case. The 4-prong test says that if the test is qualified, then the restriction can be due to the reasonable assumption. Your lordship,
So if you go to the present mood issue, the restriction is on the cause of minority.
indeed, your lordship, exactly, your lordship.
So if we are looking at this point, state can impose restrictions.
Indeed, your lordship.
So otherwise the state has restricted.
Why do you say this is against Article 21? Just have a look at Article 21.
Your lordship, Article 20, the council would like to state the case of J. Swami.
Article 21 itself says that you shall not be deprived of your life or personal liberty
Indeed, your lordship.
unless according to law.
Indeed, your lordship.
So Article 21 also says if the law is there, they can restrict your personal right and
Your lordship,
liberty.
if your lordship permit, the council would like to just take the 4-prong test, your lordship. Even if the due process of law has to be followed, it shall follow the 4-prong test to make a law which makes restrictions, but at the same time which is valid, your lordship. The 4-prong test is that the first, it shall have a legitimate aim. The state is okay, the state is having a legitimate aim right here, but it shall also bear a rational reason to that aim. Even that test can be said to be clarified, your lordship. But the further two
Do
tests
you agree that living relationship is per se immoral?
is
Per se, living relationship is per se immoral.
your
You
lordship.
should officially get connected with the opposite side.
Your lordship
Then lead your life.
Your lordship,
So
any
this relationship is immoral.
indeed, your lordship.
If it is so, it is 30%. You want to make it 50% or 100%?
Your
You
lordship,
are
it
not
is.
having any law on this side.
Your lordship, it is not the council which is giving recognition to the living relationship. It is the state that has given protection itself, your lordship. The council, the state on its first place has given recognition registration, your lordship, which would lead
The
to.
state is restricted.
But the restrictions do not meet the classification under the basic structure of the constitution, your lordship. The basic structure says that any law should first pass the test under chapter 3 of fundamental rights, your lordship. And that is what the council.
Therefore, I asked you, what is the fundamental right?
Indeed, your lordship.
21 says your liberty can be restricted
Indeed, your lordship.
in terms of law.
But, your lordship, what the
So
court.
this is the law which restricts your liberty in larger interest in the society.
But at the same time, Your Lordship, the Honorable Court in the 9th Judge Bench of case has sometimes recognized that Article 21, the right to life and liberty, the word liberty, it shall include the right to privacy, Your Lordship. And when they are including the right of the privacy of the individual, Your Lordship, they are ungoverning the personal matters of the living relationship couple, Your Lordship.
Personal matters of person living relationship has to be maintained. Law requires only registration of this living relationship so that state has the data about how many people, say 30%, no even 50%.
So your privacy has been maintained, subject to the restrictions under the law.
But Your Lordship, the council would like to move respectfully disagree that the privacy, when such information is being passed on to parents, Your Lordship. Your Lordship, no couple would like their parents, if they would have wanted to, they would have indicated the
Something
parents.
out of conviction, to feel that there is nothing wrong in living relationship. Why should we afraid about information being given to parents?
Because, Your Lordship, such things can lead to oral killings, Your Lordship. There are multiple crimes that we have seen in the backward areas, Your Lordship. If the parents are not happy with the relationship they have with it, which can be, let's say, inter-caste relationship, Your Lordship, the parents might even lead to oral killings, Your Lordship. That will further increase the criminal rates, Your Lordship.
This is all hypothetical, what you are saying. Not provide complete for information to be given. There will be no further intervention.
Well, I you want to live without any restriction. That is what you want.
Your Lordship, there are multiple things the labor relation can be regulated and it can be, restrictions can be
It's
imposed.
necessary, otherwise man can go wild. Man can behave like an animal.
Your Lordship, the council agrees with the same, Your Lordship. But there are a few problems that the council would like to point out in the act, Your Lordship. There are a few.
One issue. Indian society knows two people are living together. Indian society knows. Inform your parents is wrong.
Your Lordship, the council would
They
like to.
try to restrict, they try to regulate.
The council,
Not
Your
in-
Lordship, the council would like to.
How do you say that it is affecting your privacy?
Your Lordship.
If, for example, the police come to your house night time and ask where are you, how what you doing, yes, privacy. How in this case privacy affected? They try to regulate and they tell you, Indian citizen knows that. So you can say two people are living together. In that case, how they are affecting the privacy?
Your Lordship, the state cannot moral police their citizens, Your Lordship. The fundamental rights they shall always prevail over moral policing, Your Lordship. The council would like to highlight that reasonable restrictions can be imposed, Your Lordship. But there are a lot of drawbacks in the Act, Your Lordship. The council would like to draw Your Lordship's attention to page number 7 of the proposition, Your Lordship. Your Lordship, section 2 clause N. It says that shared household means a household where a man and a woman, not being minors, live under one roof in a rental accommodation or a house. Page number 7 of the proposition, section 2 clause N, Your Lordship. The council would read the definition for the Lordship's reference. The definition states that shared household means a household where a man and a woman, not being minors, live under one roof in a rented accommodation or in a house owned jointly or by any of them. Your Lordship, if we go by the strict interpretation of this particular definition, Your Lordship, let's say a man and a woman are cohabiting in a rented apartment for the purpose of a PG. There are multiple co-living PGs in the country of India. There are multiple rental places with their roommates and with their partners. They are allocated by the company itself. And they don't have a choice in it, Your Lordship. A guy and a girl might be staying in an apartment, maybe to share the rental expenses, Your Lordship. Even if they don't have any relations that are in the terms of the nature of a marriage, or if they are not in terms of the nature of a relationship, Your Lordship, still they shall be made to register a statement under this Act, Your Lordship. And if they don't register a statement, Your Lordship, they will be penalized under Section 11, Your Lordship. That is the problem, Your Lordship. Even if they don't have any relationship, still they are being penalized.
This law protects everything and prohibits what is prohibited under Section 5. All liberties are protected. But in order to see that Section 5 is not violated, it is prohibited relationship.
Your Lordship,
See,
the panel.
this provision which you have read was shared
Indian
would
law.
apply to say two law students studying in say Pune or Bangalore, and one boy and one girl may be living in a shared flat.
Your Lordship.
But that doesn't mean that they are living in relationship, because what is living relationship is defined in subsection 5, just read section definition section 2F. Living relationship means a relationship between a man and a woman who cohabit in a shared household in a relationship in the nature of marriage, provided that
Your Lordship,
so that it is defined.
but Your Lordship,
So it should be repeat. one boy, qualified boy, sitting in one room, pursue their studies in a
Your Lordship, the council would like to assert that nowhere in the Indian law it has ever been defined what is the meaning of the nature of marriage. A couple can be married and they might not even talk to each other for years and still live in the same shared household, Your Lordship. Is that nature of marriage, Your Lordship? It is against
That is the problem with the couple who gets married.
Indeed, Your Lordship. The council agrees, Your Lordship. In that case, Your Lordship, to define the nature of marriage is very difficult, Your Lordship. And hence the possibility of this particular act.
Anyway, your time is over, let's say that.
Your Lordship, the council would like to summarize the arguments. It was an argument to the court. The council would only like to request half a minute for the prayer, Your Lordship.
Okay.
Therefore, in the light of issues raised, arguments advanced and thoroughly cited, it is most humbly submitted before the Honorable Supreme Court of India to hold the application of the Andhra Pradesh Revision Act outside the territory of Andhra Pradesh as unconstitutional. Second, to hold the powers of the registrar under the Act to be unconstitutional. Third, to hold the Section 12 of the Andhra Pradesh Regulation Act to be unconstitutional and ultra virus. Fourth, to hold the Section 9, Section 12 of the Andhra Pradesh Regulation Act to be unconstitutional and ultra virus with the Constitution. All of which is most humbly submitted and not pass any order in the interest of this.
Thank you, we'll consider it. Next.
So in short, what is that is the
No, Your Lordship, only the section.
Then nothing
Your
remains.
Lordship, only section 9 and section 12, they can either be modified or they can be struck down or the court can grant an interpretation which suits the parties, Your Lordship. That's all the council brings up. Much obliged.
Respondents are requested to make their submissions.
Council seeks permission to approach the live.
Yes.
Council seeks
Sir, your council number what was
Council
what?
Put your mic on. That's the first thing. It's on. You can see.
Greetings. Greetings to the bench. This is Council number 1, appearing on behalf of the petitioners, appearing on behalf of the respondents of Team Code TC01 in the case of Citizens for Democratic Rights versus the State of Andhra Pradesh. The public interest litigation has been filed by the petitioners under Article 32 of the Constitution of India in Honorable Supreme Court of India. Your Lordships, the councils on behalf of the petitioners have miserably failed to address the issue of the maintainability of the present public interest litigation which has been filed by the petitioner. The maintainability aspects with respect to the violation of fundamental rights and the alternative remedies that they have to approach the High Court under Article 226 of the Constitution of India has not been invoked by the petitioners. The High Court of Andhra Pradesh has a much wide powers under Article 226 which deals not only with the violation of fundamental rights but with the violation of legal rights as well. In the present case, the state of Andhra Pradesh has made a law to protect the living relationships, the law to govern the living relationships, the law to provide living relationships the legal recognition, the much needed legal recognition, which is the need of the hour. In the factual matrix of the Moot proposition, it has been stated that 30% of the people in younger generation are living in a living relationship and 80% of people prefer living relationships, which shows that the living relationship is being all over the state of Andhra Pradesh and there needs to be a law to govern this principle. Your Lordships, there are 4 issues which are being dealing with the Moot proposition. The first 2 issues regarding the applicability of the Act and the maintenance sections, that is section 12 of the Act will be dealt by the Council number 1 and the last 2 sections which is with respect to the duties of the registrar and the powers of the registrar will be dealt by the co-council. The Lordships, under section 1 of the Moot proposition that is regarding of Andhra Pradesh, the extent of the Andhra Pradesh, the petitioners contended that this law does not come under the doctrine of territorial nexus and violates the territorial boundaries. As for the section 2, as for the section 2J, which defines the ordinary resident, means any person who has an Aadhaar card or a voter identity card will and have an address of a Vidya Pradesh will be governed under this act. Your Lordships, I would like to prove this point with the help of an analogy. For example, an 18-year-old girl who has just done with her schooling, has passed class 10 and class 12 to the state of Vidya Pradesh and moves to any other city for the further studies. For example, to Mumbai, Bangalore, any city can be taken. And there she comes into a living relationship with any man. And that man is already married or is already in a living relationship. So this concept of registration, this concept of territorial nexus will be governed to that girl. That girl is a subject matter of the state of Vidya Pradesh. And we don't know that, we cannot imagine also that till what extent that girl can be exploited in that living relationship. She is just of 18 years of age, and if there is no parental consent also, parental notification. There is no parental consent. The individual don't require any parental consent. It's just a notification. They will be giving just an information. That information, there should not be any compulsory consent by the parents or adults. So this law will govern her. This law will protect her from the exploitation. In the state of Vidya Pradesh, the women are vulnerable to options. 20% of women face domestic violence cases higher in living relationships in comparison to marriage options. This law will guide them to govern the living relationships. There was some recent insistence of the news laws. Recently, OYO, the company of hotels, banned the couples from booking any hotel without unmarried couples from booking any hotel. So lordships, if they have the registration certificate of living relationships, they can easily check in into any hotel. This law will govern them. This law will grant them protection, the legal recognition. The living relationship will be no longer considered as an immoral. It will be legal in the eyes of law. Also, recently a Noida residential building asked the living couples to submit the parental consent notice, or they ask them to provide them the marriage certificate. If the law is applicable, then they can easily show the registration certificate of the living relationship, which will govern them and protect their rights. This law is for the protection, and the protection comes with some sort of restrictions. Where there is a right, there has to be some duty of conscience.
You are not objecting to this petition on merits, on maintaining it.
I am objecting to lordship because there is no violation of fundamental rights. The presumption of constitutionality lies with the respondents, that is the
Are you
legislature.
aware of any PI rules framed by the Supreme Court?
Certainly, Your Lordship, the PI rules, the Justice P.N. Bhavati and Justice Krishna J. Iyer, these over the years have evolved the concept of locus standi in the PIs. Even the courts have taken the suo motu cognizance in the cases of bad condition of prisoners. The locus standi rule is not that much rigid, but the main essential to approach the Supreme Court is the violation of fundamental rights. As the Honorable Supreme Court is the protector and guarantor of the fundamental rights, and in the present instance, there is no violation of fundamental rights. In the landmark case of Anuradha Basin versus Union of India, whole state of Jammu Kashmir was banned from using internet, and that too till the unreasonable time. But in that case also it was held that when the matter of the security, when the matter of the larger state interest is in question, the fundamental rights are liable to be restricted to some reasonable restriction. The public policy, morality, decency, and the security are the reasonable restrictions guaranteed under Article 19 law.
Do you agree that violation of Article 21 is there?
Certainly not in lordships. In the case Mukti Swami case, which has been cited by the petitioners, in that case also, which is well known as the Aadhaar case, the Supreme Court held that a reasonable restriction to the privacy will not be termed as an unconstitutional your lordship. In that case also, the government proved that only the limited information will be taken by the petitioners. So that case also was under the ambit of the Constitution and was not, the Aadhaar was not held unconstitutional. Is it constitutional as in working in the whole country of India? Your Lordships, when the presumption of constitutionality is in the favor of the legislature. In the case of Ashutosh Gupta versus State of Rajasthan, it was held. There is always a presumption in the favor of the constitutionality of enactment, and the burden is upon him who attacks it to show that there has been a clear transgression of the constitutional principles. It must be presumed that the legislature understands and correctly appreciates the need of its own people, Your Lordships. The government of Andhra Pradesh has not enacted any law in just one day. We have researched the ground level report. A law commission has been formed to address this issue. And after the recommendation of the law commission only, this law was enacted to protect the living relationship couples.
So therefore there is nothing wrong with the law, that's what you want to say.
Certainly, indeed, Your Lordship. But if there is something wrong, which has been the respondents get to know, they have the power to make rules under Section 15. The law is an evolving concept. It is not
What is
constant.
your answer to the submissions made by them? They say it is a validity of Article 21 on these lines. Because of this, what is your reply to them?
Certainly, Your Lordships. Your Lordships, they said that their contention, the recent contention was regarding the shared household concept under Section 2A. They say that if a flat made a legal students are cohabiting under one roof without having any living relationship sort of relationship, that is a relationship in the nature of marriage, then too they will be penalized and criminalized. Lordship, I would like to refer to Section 10 of the Andhra Pradesh Living Relationship Act, which is regarding the notice for registrations of living relations, which says where any partner to a living relationship has failed to submit a statement of such relationship, the registrar, either of her, his own motion, or a receipt of complaint or information in this regard, shall by notice requires its partner to submit a statement in a prescribed manner within 30 days. The 30 days time period is being given to the couple to tell the reason that why the submission of statement is not being recorded. Enough time and enough chances. They said that there is no concept of oddity alternate partner. This is the best example that this act has the concept of oddity alternate partner process. Then certainly, then the contention was regarding the Section 3, Section 6, regarding Section 6 and Section 9. That is the duties of the registrar and the procedure of the registration process. Lordship, the procedure of registration of living relationships mentions persons in a living relationship or a person intending to enter into a living relationship shall submit a statement of living relationship to the concerned registrar in such format and in such manner as may be prescribed. In this, there is no violation of fundamental rights. Whenever we go for any registration processes, whether it is a registration process for a marriage, whether we go for applying for a driving license as well, the minor information, the Aadhaar card, the voter identity card, the address proof has been asked, and these all things are already into these all data is already into the domain of the state government. So we are not asking anything which is confidential, which is infringing their privacy under Article 20. These are the minor reasonable restrictions which are necessary for the major state interest. See,
the petitioner informed that the present law is arbitrary, violates Article 21, it does not follow the due process. It does not comply with the Article 21 of Constitution, that is due process. Can you order this?
Certainly, Lordship. The whole due process of law has been followed. The Section 5, which the petitioners contended, that is regarding the prohibition of relationships, that the petitioners are not getting the chance to choose their living partner. Your Lordship, the prohibited living relationship, Your Lordship, the Section 5 simply says 4 points regarding the prohibition of living relationships. The first is the minor, the second is the free consent. DNA tests and all, these are not, these are not fundamentally correct. So to
Once there are multiple living relations, this life will be rich, and this life will be answer. They should get registered. If you have multiple living relations, this life will be rich. Those who are not multiple relations, they are trying to, once they register, they will be rich.
Your Lordships, under this Act, there will be a submission of statement by the living partners regarding the living relationships. And the Section 5 will not allow them to enter into multiple relationships. They can register a living relationships. After that, there is a provision of termination of living relationships. And if they in future want to come into any further living relationships, that is also permitted in law. We are not restricting their any rights at the whole. They are just a minor, just a reasonable restrictions which are essential laws.
Any particular answer to your submission on section 11 of this Act?
Certainly, Your Lordship. The section 11 is regarding the offences and punishment. They pointed out that though just for a 1 month delay, the couple will be penalized, the couple will be behind the bars for the 3 months. So the answer for this is the section 10 only, which says that if there is a possibility that any couple has not submitted the statement, the 30-period time will be given to them by the registrar to answer to that notice, that why there was a delay. And also, the punishment clause says that whoever stays in a living relationship for more than 1 month from the date of entering into such relationship without submitting the statement of such relationship under subsection 1 of section 6 shall be punishable with imprisonment for a term which may extend. It means the maximum punishment in 3 months, and also or with fine. Or with fine means that it is not compulsory that the imprisonment will be there. Or with fine. It doesn't say and with fine. It says or with fine, not extended to 10,000 rupees or both. Means a minor fine that is regarding the 500, 1,000 can also be taken if we breach any traffic rules also, Lordships. If we don't have a driving license and we are driving any vehicle, then too there is a fine. For every right, there is a duty that has to be fulfilled.
1 month's time is not inadequate according to you.
Your Lordships, it is not inadequate. Inadequate because after the 1 month, the 30 days duration for the notice is also given. So it will be implied that the 2 months time is given, and then it's not a 1 month time. Your Lordships, then the first issue regarding the extraterritorial jurisdiction. The judgment cited by the petitioners is regarding the state of Bombay versus RMD Chamaru Boghiwala. In that case, the law was laid down in the favor of petitioners. In this case, the doctrine of territorial nexus was upheld, and it was held that the petitioner, though situated in the state of Bangalore, will be held under the sales tax laws of the state of Bombay. So the judgment cited by the petitioner will not be taken into granted. Also, they cited one more judgment, which was regarding the service law. The service law judgment of proportionality. How can that judgment will come into picture in the case of a personal law? The judgment is regarding the Sri Lekha Vidyarthi versus State of. It is a service law judgment, Your Lordship. How this judgment is applicable in a personal law case? They only said that these personal laws, right to privacy, then a service law judgment can how be applicable in the case of personal
The
law.
context of service jurisprudence is different.
Yes, so the facts are completely different. Also, Your Lordship, in the case of Indra Sharma versus BKV Sharma, the guidelines are given by the Honorable Supreme Court regarding the law to determine relationship in the nature of marriage. The law completely laid out how and when the relationship will be termed as a nature of marriage, and though it is not a marriage, but will come under the ambit of relationship in the nature of marriage. Whether and how frequently the parties live in the same house, whether the parties have a sexual relationship, whether the parties give each other emotional support and companionship, whether the parties socialize together or attend activities together as a couple, whether and to what extent the parties share the responsibility for bringing up and supporting any relationship. Whole guidelines have been given by the Honorable Supreme Court only, and with the help of these only the respondents have formed a law. In the recent case of Hariram Simar versus State of Rajasthan, the need of the hour was upheld to form a law to govern the living relationships in law.
Also, we mentioned the case about VKV Sharma, okay? In that we highlighted, living or marriage relationship is neither a crime nor a sin. We highlighted the sentence. In the Sharma versus
Yes, Lord.
here, the second point it is,
Yes, Lord.
neither a crime nor a sin.
Yes, Lord.
So is living relationship followed in India?
It is being followed over the years in a large number of lawsuits. There are multiple petitions in the Honorable Supreme Court. The right of maintenance of women in the living relationship was upheld. Even the Protection of Domestic Violence Act also accept that if a man and a woman, the heterosexual couple, is living in a shared household, it will be termed as a relationship in the nature of marriage. The living relationships are practiced in a wide number in the
But if you look at Indian society, many people oppose, and even government is trying to prohibit.
Lordships, we are not trying to prohibit. This is only the issue that the people are not ready to accept the living relationship act. There are multiple cases of honor killing, false rape cases, maintenance issues.
So those are the different issues, not the living relationship. They are different issues.
Your Lordship, the false rape cases are increasing day by day. The female or the female counterpart is living in a living relationship for past 5 years. But if the person, if a man rejects from the marriage, then the false rape case against that man is filed. So if the living relationship will be registered, there is a proof for that man to protect him that it is not any false rape case, but it was a living relationship. It was a
However, Indian situation, these cases are very rare, not regular cases. The pattern is very low.
Certainly, Lordships, but in the Moot proposition it is mentioned that 80% refer. So if they are not in, they are intending to come into the living relationship. So if there will be a law, they can easily register, they will be easily protected. The law is not, in the Supreme Court judgment only, the law said that it is not illegal to be in a living relationship. It can be immoral, but it cannot be illegal. And to that, to prohibit that immorality, to change the thinking of the people. Earlier, Section 377 was also the LGBTQ rights. The people think the people not respected the LGBTQ rights. They were not granted the equal freedom. But after the Supreme Court struck down the judgment, they are provided the rights. They are getting the recognition. Not that much, but the law is changing.
According to you, though living relationship cases are very unique, though it is paradoxical to Indian ethos and Indian society and Indian culture, law was required to regulate it, but for this law is
Certainly, Lordships, the Personal Marriage Law Acts, the Hindu Marriage Law Act, the Parsi Marriage Act, do not govern the living relationships. They govern only the marriage. So, when the law will, so the law is required to govern
What is
the.
our mandate in Rina's case currently?
Pardon.
Rina, you have just cited. Rina was the state of Rajasthan. What is our mandate in that case?
Certainly, So, your Lordships, this judgment has been referred to a larger bench because in this there was a married person who is married couple who is in the living relationship as well. That's why this judgment has been referred to a larger bench for the further consideration. And in this judgment, it was held that it is a need of the article because multiple petitions daily under Article 226 have been filed in the different high courts.
Yeah.
page number 11 of the judgment. The need of the hour is to take a step to bring out a law or enact a new legislation which would look into the matter of living relationship and would grant rights and impose obligations on the part of the couples in such relationships. A separate
So the
legislation.
judgment recommends new legislation in a sense.
Certainly, Lordship, also the
You want to
Gujarat.
say that this law has been made pursuant to the directions of the Indian.
No, Your Lordship, this judgment came much later. The law was enacted earlier, Your Lordship. The law was in force on 26 November 2024, and this is the recent judgment of 27th January. Your Lordship, recently the Uttarakhand government has also
Time
enacted
is over.
certain, Your Lordships. Much of like, Your Lordship. It was really an honor acting with you. Thank you.
Council seeks permission to oppose the policies. Much obliged to your service. Greetings to the bench. This is Council TC01, Speaker number 2, appearing on behalf of the respondent in the case of Citizens for Democratic Rights versus State of Vidya Pradesh. Your Lordship, I would be dealing with the remaining two issues, that is issue number 3 and 4. If there is no preliminary inquiry by the bench, then Council begin with the issues. Much of the Your Lordships. Your Lordship, issue number 3 deals with the registrar's power to decide on registration of a living relationship is violative of fundamental rights. It is humbly submitted before the Honorable Supreme Court of India on behalf of the respondent that the registrar's power on registration of living relationship is non-violation of any fundamental right. It is most respectfully submitted on behalf of the respondent that Vidya Pradesh Living Relationship Registration and Regulation Act 2024 is not regressive, arbitrary or unconstitutional in nature. Rather, it is a necessary legal reform addressing the realities of modern society, Your Lordship, as change is the only constant. As the modern society is changing, hence to deal with the new issues, as this has been held in the landmark judgment, in the judgment given by the Rajasthan High Court, that this concept of living relationship is unique and new to the society. To deal with this, the new concept has come into the existence, and there are some legal complications which are taking place. Hence, to deal with the same, the law has enacted in the state of the Pradesh. This regulation is not a restriction, rather it is a protective mechanism which is safeguarding them from any sort of adverse situation they might come across in the coming future. And this act is ensuring fairness, security and legal certainty. Fairness, Your Lordship, as in these living relationships, there are no as such particular law which will governing, or there is not any regulations under which living relationship has been taken as or any law which is recognizing living relationship and also giving a security. Your Lordship, it is pertinent to note that the necessity of regulating living relationship is not just a matter of debate, but a legal reality acknowledged by both the legislature and the judiciary. Your Lordship, in another Indian state, that is Uttarakhand, has implemented Uniform Civil Code 2024, which that state also has laid down the laws and regulating guidelines that and act which are regulating the living relationship in the form of UCC clause 378, 388. This code also deals with exactly the same way how Vidya Pradesh is enacted. And also on the other hand, the judiciary lordships, in the case of Hariram versus State of Rajasthan, the High Court of Rajasthan seeking that the lordships in the judgment of Rima, which has been, the submission has been page number 11, paragraph number 16, in absence of any legislative framework in relation to the relevant subject matter, any people get many people get confused due to different approaches of the court. Although the court attempts to fill the vacuum in law, still there remain uncertainty and fragment application of law. The need of the hour is to take a step, bring out a law, or enact a new legislation which would look into the matter of living relationship and would grant right and impose obligation on the parts of the couples in such relationship. A separate legislation should be competent enough to grant assistance to the children, female partners who become sufferer in such relationship. Your Lordship, in other states, the High Court is asking government to bring the legislation. India Pradesh was way more ahead and they have enacted the law. In another state, that is Uttarakhand, they also have enacted UCC in which there are regulations which are governing or regulating the living relationship. Your Lordship, it is not just the need of, it is not just from the side of a judiciary.
Your case is that this complies with the mandate of the Supreme Court of India.
Pardon me, Lordship.
This law, which is being essayed now by the other, it satisfies the mandate of the Supreme Court judgment. In our case,
Judgment of the Rajasthan High Court. I didn't get the pardon.
this law satisfies the mandate of the judgment. In our case, Supreme Court judgment is in our case. In our, that's how we are.
This judgment is of Rajasthan High Court, Your Lordship, not the Supreme Court. Your Lordship, so do you.
Yeah, it satisfies the mandate of Rajasthan.
Certainly, Your Lordship. Over here, what the Rajasthan High Court is stating that their separate legislation should be competent enough to grant assistance to the children. In the present law, by the Vidya Pradesh, the status of the children is given as legitimate children. And also, when it comes to and the female partner who became sufferer, there is a difference provision under section 12 of the Act. And these two, what the Rajasthan High Court is asking to the legislature now, all these criteria is fulfilled in the present law. Hence, if the judiciary is seeking the same, how the present law can be is in violation of the fundamental regulations. And also, Your Lordship, it is not just the judiciary or the legislature of the other state, but as a citizen of the country is also seeking a.
This law is not of Rajasthan High Court, it is Indian Pradesh.
It is Vidya Pradesh. Your Lordship, the council on behalf of the respondent is actually taking into consideration of different state approach as where there is no enacted law on regulating the living relationship. They are asking for the law. On the law, what they need is the law that the maintenance for the female sufferer or the status of the children. They don't have law, they are seeking for the enactment of law. But Your Lordships, when it comes to Vidya Pradesh, it is already been enacted.
You say that court as per Rajasthan High Court stands finds especially in this act.
Certainly, Your Lordships. And also, Your Lordships, petitioner contended that maintenance under section 12 is in violation as it is gender biased. Your Lordship, it is pertinent to note that there is exception to it under Article 15 Clause 3 in which the state can form a law or a legislation which is women-centered for women and children. Your Lordships. There are many laws which are made to protect the women, like POSH, protection of women from sexual offences at workplace, for Sati Pratha, Your Lordship, for widow remarriage, for dowry. So these are the laws which have been implemented from central point of view and to protect the women. These are not against the women. These are not against the principle of fundamental right or violation of the Article 14, because this is not inequality. Equality should be done within the equals and unequal between the unequal lordships. Also, Lordships, the Mamta Rani versus Union of India, the petitioner sought centralized law regulating living relationship, citing the rise of false rape case where women falsely claimed living relationship with the accused. Your Lordship, it is pertinent to note that there was a PIL filed before the Honorable Supreme Court of India under Article 42, known as Mamta Rani, citing Mamta Rani versus Bureau of India. After the petition reference to the brutal murder case of Shraddha Walkar, Your Lordships, there was no law. The Vidya Pradesh Living Relationship Registration Regulation Act came into existence in November 2024. Prior to that, were not there 20% higher domestic violence? It was more than the marriage. There are offences that have been committed within the living relationship arrangements. There are false, Your Lordships. Also, when it comes to a summary inquiry done by the registrar, it is to protect both of the partners, either of the partners, not only the female but also the male. If what is the one of the partners hiding his identity, what his name, his religion, his background, is he married or is he to living relationship currently? It is, Your Lordships, registrar is being empowered to let another partner know everything about the another partner. What if the fact which has been hidden from another
Say
partner?
registrar has been given excessive powers.
Certainly not, Your Lordships. Certainly not. These certainly not, Your Lordships. Where these are some reasonable restrictions.
Who are proposing to be in a relationship belong to different religions. Can the registrar refuse to register?
Certainly no, Your Lordships. But taking into the consideration, both of the partners are aware about each other's religion. There should be no concealment, misrepresentation, coercion. There should be free consent from either of the partners or each other to come into a living relationship. These powers has been given to the registrar. And there is no excess.
Persons who are beginning to living relationship should take an informed decision to live in living relationship.
Certainly, Your Lordships. Certainly, Your Lordships. Your Lordship, in the case of Abdul Hamid Siddiqui versus Kavita, Justice High Court recognized that women in such relationships are often victim of violence and abandonment, particularly when their partners are already married. Your Lordships, there are so many cases where one person is married, hiding his marital status, coming into a relationship with another partner. It is violating the other partner's fundamental right, Your Lordships. The government, Your Lordship, the Vidya Pradesh government has responded and urgent need as petitioner have filed. Also, Your Lordships, in the case of Haryana versus state of Rajasthan, in that page number 9, Your Lordship, para number 10, several couples are residing in living relationship and are facing threat and danger for their families and society for accepting their relationship. Hence, they are approaching the constitutional court by way of filing writ petition under Article 226 of the Constitution of India, seeking protection for their life and liberty under Article 21 of the Constitution of India. As a result, courts are included with such petition. Every day, dozens of petitions are being submitted under the similar prayer of protection of life and liberty from danger and threats faced by such persons. Your Lordship, in some way, every living relationship, there is no regulation. Hence, the chances of honor killing, hence they are asking for protection from the court under Article 226. Your Lordships. Hence, Your Lordship, the High Court of the Rajasthan is also seeking there should be law to prevent the offence that are being committed against the living relationship partners. If there is no law, then there are more threats to the couples. After enacting the law, enforcing the law, actually the law is protecting the living relationship. Your Lordship, and recently the Uttarakhand High Court Legal Bench has said that petitioners have approached this court for protection. According to them, they belong from different faiths and are residing together in living relationship. Due to which, the parent and the brother of the petitioner one are extending threat to them. Your Lordship, they are not governing under the Act. If, according to the petitioner, if they register themselves, then there is a threat of honor killing. Your Lordship, they are not governing under the Act, still they are facing the same. Instead, when once the couples are getting registered, they are being legally recognized. Also for summary inquiry, the information has been recorded to the local police station also, via which the state is giving them legal recognition and protection. The society yet is not that much has not accepted the new concept of living relationship so easily. It is a new concept for the society, but change is the only constant structure. As the increasing number of living relationships, being a legislature, being a government of state of Andhra Pradesh, it is our duty to protect our residents at least elections. Also, Lordships, in the case of Shakti Vahini versus Union of India Matters, the Supreme Court of India, page number 32, Lordships, regarding the honor bill, paragraph number 75. One may feel my honor is my life, but that does not mean sustaining one's honor at the cost of another. Freedom, independence, constitutional identity, individual choice, and thought of a woman, be a wife or a sister or a daughter or a mother, cannot be allowed to be curtailed, definitely not by application of physical force or threat or mental cruelty in the name of self-assumed honor. Your Lordship, these principles are present in the present Act, Lordships, and this Act is protecting the couples, partners from threat or any offense such as honor killing.
Also, when I refer to living relationship, it is with consent, voluntary, there is no force.
Certainly.
But if ever honor killing is completely definition. Honor killing is completely definition, the relationship is about living relationship.
Living relationship is within the consent of both the parties.
Yes.
But the society contains their family also, Lordships. Family does not, if the partners are from two different castes or religion. As I just referred, Your Lordships, by the judgment of Gujarat High Court, Rebuttals bench, over here, they were in living relationship from different faith. They are getting threat of honor killing, Your Lordship, from their father and brother. And Your Lordship and the judge what suggested was,
See, if you refer to the data of the other India, honor killing is completely subject topic and living relationship is completely different. They don't even in this book. Anyway, if we see this decision, they very different.
pardon me, the last time.
The relationship, they favor living relationship very rare cases, not many cases. The data is very low. In this situation, how can we link with honor killing and living relationship?
Your Lordships, right now, the number of living relationships might be low. As it is growing, as it is increasing according to the time is changing. When it comes to honor killing does not apply to every case. But in any case, if it applies, if the partners have registered under this Act, they will be granted protection. They have legal recognition. These are the contents of the Respondent. Moving further, Your Lordships. Your Lordship, in the case of Chedama versus Tidama, gave the status of wife to a partner of living relationship, stated that a man and a woman, even without getting married, can live together if they wish to. This may be regarded as immoral by the society, but not illegal in the eyes of man. There is a difference between law and morality. The bench went a step ahead and observed that children born out of such parents would be called illegitimate and they have a right in their parents' property. Your Lordship, this judgment is given by the Supreme Court and the same principle is implied in the present Act also. So there is no violation or in contrary or conflict with the principles laid down by the Supreme Court or the legislation enacted laws, Your Lordships. It is aligned with the principle of natural justice, audio partner, the 30 days given to the partners to answer the same. They have a right to keep their votes. What are their stand? And also, Your Lordships, there is no violation of fundamental right as such. Your Lordship, mere difference or inequality of treatment does not mean for say amount of discrimination within inhabitation of legal equal protection clause. However, it is settled principle of constitutional law that equality does not mean absolute uniformity. Rather, it requires that equal must be treated equally and reasonable classification is permissible. Your Lordship, page number 34, case of Ramana versus IAA, a guarantee of equality extends to right as well as privilege. The principle of equality does not mean that every law must have universal application to all. It just because hence, Your Lordship, it is not violating Article 14. When it comes to Your Lordship, the constitutionality of the enactment, page number 34, second point, Your Lordship, page number 34, second point. Case Prabhu Das versus Union of India, wherein the presumption is always in favor of a constitutionality of enactment. Since it must be assumed that the legislature understands correctly and appreciates the need of its own people, that its law are directed to problems and made manifest experience and its discrimination is based on adequate grounds, Your Lordships. Your Lordships, while
But if you cite the Supreme Court judgment, you are citing these small things. Where Supreme Court is different.
Apologies, Your Lordship, pardon.
When you speak about the Supreme Court judgment, you cite the Supreme Court judgment. You are mentioning commentary paragraph to cite the Supreme Court judgment. If you get the judgment here, you will find out what is right, what is wrong.
So, 25 Constitution of India.
Where one judgment of the Supreme Court is cited, you cite it before us. By getting the copy of the judgment, not like this.
Plus, in a consular case, a very old case.
Certainly,
1966 case.
but the principle which has been laid down by this Honorable Supreme Court of India is regarding
Not answering the question.
certainly Your Lordship. The principle which has been put forth by the Supreme Court of India is regarding the constitutionality of the Article 14. Certainly, Your Lordship. The principle which has been laid down by the Supreme Court of India regarding the constitutionality of an enactment is
See,
will remain the same.
every judgment is passed in the background of the facts involved in the matter.
Certainly, Your Lordship.
So facts are also relevant important and have to consider to the purpose of why the submission of law is accepted.
But Your Lordship, when it comes to a principle which has been laid down, that can be applicable universally as to that subject matter, Your Lordship.
Just to find out if the principle is universally applicable, you should read the entire judgment, not only the principle.
Certainly, Your Lordship.
You could have the entire judgment, that's right, say that.
The respondent has judgment, Your Lordship. Your Lordship, the book has been cited because the book has been a credible source
There is a judgment issue. There is that.
provided. Your Lordship. Your Lordship, the judgment of Chief Justice versus Union of India. The book is page number 34, first point.
Consular, if you find out the presumption that the probability
Your Lordship,
Judgment which is written as it is.
certainly, Your Lordship, there are certain judgments which are like the judgment of case which council seeks 32nd extension, Your Lordship. Just to answer your question, Your Lordship, there are some certain judgments like case Petitioner. The judgment consists of 1,500 pages. So it is sort of inconvenience to the council or to carry that. Hence, the relevant part.
No, it's not a case.
Now is the truth. You do not have the judgment in entire country.
Entirety,
It is not there. That is how truth should be extracted.
certainly.
The volume of the decision cannot be a ground to say that relying upon that decision.
Your Lordship, when it comes to the principle which has been a benchmark or the landmark of the principle has been set.
Facts of our case.
Because you say that when not we should accept, we have to check it.
Certainly, Your Lordship. Certainly, Your Lordship. Right, under Article 21, right to life and personal liberty, right to privacy is also a fundamental right. It has been held in case Petitioner. You know, Your Lordship, this is the principle has been laid down that under Article 21, right to privacy will come into existence.
Subject to procedural restrictions. Subject to law.
Subject to procedural restrictions. But this principle has been laid down that their privacy is a fundamental
One
right.
is not absolute.
Certainly, Your Lordship, but it is a fundamental. None of the fundamental right is absolute. As a state, as a respondent, their state has a competent authority to put reasonable restrictions. Certainly, Your Lordship. But once a principle, once a judgment has passed that right to privacy is a fundamental right, this can be applicable to cases also, to the present case also, Your Lordship. These are the principles which has been set forth by the
Answer
state.
his submissions. That will help you.
Certainly, Your Lordship.
Anyway, the time is over.
Council seeks permission for the prayer, Your Lordship.
Okay.
Council, thanks to Your Lordship. Therefore, in the light of the facts stated, issue raised, argument advanced, and authority cited, the respondent respectfully prays for the following relief from this Honorable Supreme Court of India. The Council, on behalf of the respondent, thereby most humbly and respectfully, in the interest of equity and justice, it is prayed and implored before, hold and declare that the Vindhya Pradesh Living Relationship Registration and Regulation Act 2024 is constitutionally valid and applicable within the legislative competency and does not violate any provision of the Constitution of India. Uphold the validity of Section 12 of the Act as it is a reasonable and lawful restrictions in furtherance of public interest and does not infringe upon the fundamental right enshrined under Part 3 of the Constitution. Declare that the power vested to the registrar under the Act for registration of living relationship is a regulatory mechanism which does not violate the fundamental right of individual, but rather ensures accountability and legal protection. Hold and declare the Section 9 of the said Act is constitutionally valid and does not contravene any fundamental rights guaranteed under Part 3 of the Constitution. Pass such other order direction as is honorable court may deem fit and proper in the interest of justice, equity and good conscience. As this act of kindness, the respondent as in duty bound that shall every. Much obliged. It was an honor argument for you, Lordship.
Adjourn that.
Petitioners are requested to proceed with their argument.
The council's permission to close the dais. The council's permission to close the dais. Your Lordship, before proceeding with the rebuttals, the council would like to clarify that the council is not against the act per se, the council is not against living relationship per se, but the council is against the provisions under the act which are unconstitutional, Your Lordship. Your Lordship, the council would like to pose a few arguments about maintenance, Your Lordship, since the same could not have been dealt with before properly. Your Lordship, maintenance under Section 12 has been granted under this act, Your Lordship. The Section 12 of this act, if Your Lordships will refer, it reads as, if a woman gets deserted by a living partner, she shall be entitled to claim maintenance. Your Lordship, why is it only the women who shall be entitled to claim maintenance or desertion, Your Lordship? Your Lordship, Section 8 on page number 9 of the same Act. It says that either of the parties in the living relationship may terminate it by simply submitting a statement of termination before the registrar, Your Lordship, which means that the right to desert the partner is equally available to the man as well as the woman. They just need to submit one statement of termination, Your Lordship. Hence, Your Lordship, why should only the woman be allowed maintenance, Your Lordship? If the woman deserts the man should also be maintenance, Your Lordship. Your Lordship, the council could also reiterate on the fact about maintenance itself, Your Lordship. The Act says that any person who is not a minor can enter into a living relationship, which implies that any person who is above the age of 18 years can come into a living relationship. Your Lordship, is a person who is 18-year-old, who is 19-year-old, capable of granting maintenance to some other person, Your Lordship. A person who is going to college, who is pursuing his higher studies, he doesn't have money for his own expenses, Your Lordship. Does he have money to give lifetime maintenance to a woman that he was mainly involved with as a living relationship, Your Lordship? That is the question that the council asks, Your Lordship. Your Lordship, the council would also like to reiterate the fact that when the union of the government has already enacted section 124 of the CRPC, which is currently section 144 of the BNS, which is the umbrella section provision for giving the right of maintenance, Your Lordship, which is gender neutral, Your Lordship. That provision shall be deemed to be upheld, Your Lordship. And such provision for maintenance which the state has enacted, which is arbitrarily, it shall be restricted on, Your Lordship. Your Lordship, the council would now like to also present argument that the opposing counsel says that to the parents only an intimation is sent, but the consent is not to be obtained, Your Lordship. Your Lordship, it is a fact, Your Lordship, that marriages in India are only conducted by the consent of the parent, Your Lordship. A child will never go against the will of his parent, Your Lordship. That is the Indian model that we have, Your Lordship. Similarly, in this case, Your Lordship, when the parents are intimated about the status of such relationship, Your Lordship, the parents might object to the same, and the living relationship couple might eventually, rather than registering the same, might end up breaking up and might end up going up to different paths, Your Lordship. That is the problem, Your Lordship, that you are facing, Your Lordship. That is why the consent of parents shall not be obtained, Your Lordship. Your Lordship, the council would also like to reiterate on the point that the opposing counsel says that the restrictions presented by them are reasonable restrictions. Your Lordship, section 6 clause 3 of this act itself says that the registrar can summon any person, Your Lordship, who is related to that particular living couple, Your Lordship. Your Lordship, let's say there is a friend of a living couple living in some other state, Your Lordship. That person, merely by the virtue of him being a friend of the living relationship couple, Your Lordship, he shall be summoned by the registrar from the other state, Your Lordship. Your Lordship, that other person who has been summoned, he has his own fundamental rights, Your Lordship. He has his own life, Your Lordship, which is being violated. But when the registrar summons him, Your Lordship. Your Lordship, the council would also like to say that the opposing counsel is time and again saying that it is the recommendations of the Law Commission report which has led to the enactment of this Act, Your Lordship. But Your Lordship, the Law Commission is mainly a recommendatory body, Your Lordship. The provisions that are finalized in this particular Act, Your Lordship, it is done by the State Legislative Assembly, Your Lordship. And they shall take the responsibility of the provisions that are unconstitutional, Your Lordship. And they shall not put the onus of the same to the Law Commission, Your Lordship. Your Lordship, permit, the council would like to give only one more time. Your Lordship, it was an honor.
Respondents are requested to proceed with sir rebuttal.
Council seeks permission to approach. The Lordship, sir, petitioners contended that they were not able to complete their maintenance argument, so they applied the rejoinder. The rejoinder should only be the arguments that they have cited earlier and not to complete their pending arguments, so that arguments of the maintenance should not be taken into consideration. Also, Lordship, sir, petitioners contended that the provisions are unconstitutional and the reasonable restriction has not been applied, Lordship. Lordship, in the instant case, the reasonable restrictions are only applied. They said that the parental consent, the children will not go against the consent of the partners, and it is infringing their Article 21 under right of privacy. Lordship's reasonable restrictions for the security and for the large state interest is mandatory. Also, Lordship, even in the registration of marriage, the witnesses are necessary. So, if during the summary inquiry, if there is any suspicion and any person is summoned, how can this be violated of their Article 21? Any additional additional information will not consist of any confidential information. It will be on the basis of what is their name, what is identity, the address, not any additional. The additional information will not consist into any confidential information. The information will consist only that the information is available in a large domain and is public in nature. Lordship, the respondent, the petitioner cited the case of Shafeen Jahan versus Union of India. The case cited by the petitioner is in relation to the marriage and is not with respect to the live-in relationships. They only said that intelligible differentia should be observed in the marriage and live-in relationships are not equal, they are distinct with each other. The live-in relationship should not have that much strict procedure. So why the petitioners are contesting their arguments with the help of case laws that solely based on the marriage laws and not on the live-in relationship laws. Lordships, they said that they said regarding the maintenance, that if an 18-year-old boy who is not able to maintain himself, how he will provide maintenance. Lordships, this will be governed by the family courts and this will be deferred by fact-to-fact cases. There is not any compulsion that if the boy is not able to maintain himself, how he will be maintaining the another counterpart. So it will be governed under the family courts. The family courts law, it will be the competent courts will decide, will adjudicate on matters like this and will be decided on fact-to-fact basis. Lordships, also the maintenance that they cited under section 12, that why the law is not gender neutral, it is covered under Act 15 clause 3, under which the state government.
Okay, thanks a lot.
Thank
It's
you.
nice to hear you all. You are going to be future lawyers. Remember one thing, lawyers also in the part of administration of justice. Therefore, understand the law, apply the law to the facts which are applicable to your clients, not law, not untrue facts. Don't convert true facts into untrue facts, or true facts into true facts. That's how it will increase law and justice. Your arguments have been heavy. We can't just deliver the judgment right now. We reserve judgment. Thank you.
Much obliged to the Lordships. It was really an honor having you. Thank you.
With that, we come to the end of the final round of the Justice G.D. Kamat Memorial National Level Moot Court Competition 2025. I request our scoring department to kindly assist the judges with scoring.